The other big thing that's happening in these efforts to constrain these unelected black robe tyrannical, inferior district trial court judges and their issuance of these unlimited jurisdiction, temporary restraining orders, and preliminary injunctions is going to be heard by the Supreme Court on May 15th. So just 5 days from now, a whole bunch of arguments from a couple of these cases where federal judges, trial judges, have issued nationwide injunctions. The White House is now arguing to the Supreme Court. The legal question is whether the Supreme Court should freeze the unelected black robe tyrannical inferior district trial courts nationwide preliminary injunctions on the Trump administration's January 20th executive order ending birthright citizenship, except as to the individual plaintiffs and identified members of the plaintiffs actually in the case. By the way, Trump's administration executive order ending birthright citizenship, Trump did not end birthright citizenship. If birthright citizenship means you are automatically an American citizen just because you're born on American soil, that has never been American law, ever. It's not called for by the 14th Amendment. It's not called for by any of the previous Supreme Court jurisprudence on this question. If you're born on American soil to parents who are not American citizens, you inherit the nationality of your parents. You do not automatically become a U.S. citizen. I've talked about that quite a bit. And one of the arguments being made on this matter to the Supreme Court, a whole bunch of these cases, dozens of these lawfare cases against Trump involve these nationwide injunctions. So we see it brought up a lot.
Did you know that in all 50 states, self-defense law, not gun law, but self-defense law, uses a simple 5-element test to see if your use of defensive force was legally justified? And that same test applies no matter what state you're in or what tool you use to defend yourself. If you're missing even one of those required elements, however, you've made yourself an easy conviction for an aggressive prosecutor. My name is Attorney Andrew Branca, and I've worked more than 30 years as a self-defense attorney. Every state has seemingly endless, complex pages of laws regarding self-defense, so complex that many top criminal defense attorneys rely on my expert analysis to help win self-defense cases for their clients. If the legal code is that complex for lawyers, how can a citizen gun owner expect to know or even follow the law, especially when a life or death situation has triggered a massive adrenaline-fueled mandate to make that fight or flight decision right now? It seems daunting. Yet I created a simple but powerful framework that has allowed me to serve the legal community and countless American gun owners to simplify this legal complexity into just 5 elements of self-defense law. And you can learn my 5-element legal algorithm I use to consult on and win with the top criminal defense attorneys all over the country to protect law-abiding, gun-owning citizens from making innocent legal missteps that land them in prison. Now, with a simple read or listen, you can install my 5-point legal framework so it acts as a sort of muscle memory defense to protect you from losing your rights when you choose to defend innocent human life. Click below to get the latest edition of my book, The Law of Self-Defense Principles, for free. I ask only that you help cover the shipping and handling cost to get the book to you.
Here's a separate case being argued by John Sauer, Trump's lawyer, White House lawyer, the Solicitor General. He's the guy who argues to the Supreme Court on behalf of the White House. Very good lawyer. I'm not going to read this whole paper. I just want to highlight where he talks about this. Here we go. This emergency application of the White House to the Supreme Court presents a now familiar theme. An unelected black robe tyrannical inferior district trial court has issued sweeping injunctive relief without legal authority to do so in ways that inflict ongoing irreparable harm on urgent federal priorities and stymie the executive branch's functions. Here, the president adopted an 18-month Department of Government Efficiency agenda to improve the quality and efficiency of government-wide software, network infrastructure, and information technology. The U.S. DOGE service, USDS, advises the executive branch and federal agencies as how to streamline government, eliminate waste, ferret out fraud, and modernize outdated systems that let malfeasance and inefficiency go undetected. To that end, multiple agencies have made use of DOGE. These teams have a business need to access the data at their assigned agency and subject the government's records to much needed scrutiny. In response, the unelected, black-robed, tyrannical, inferior federal district court issued a preliminary injunction that compels the Social Security Administration to block access to the agency's record systems for DOGE team members and DOGE affiliates unless a host of judicially imposed conditions are met. That action followed another district court's decision to block access at the Departments of Education, Treasury, and OPM, the management arm of the government. The Fourth Circuit subsequently stayed the three-agency order for Education Department and OPM, and the Fourth Circuit denied initial hearing en banc, yet the Fourth Circuit inexplicitly reversed course here. So I'm not going to read this whole decision because it's not relevant today for us, but it's another point at which the White House is going to the Supreme Court and saying, you need to check these judges. They are exceeding their lawful authority. All right, let's take a look at the member numbers. Jada says, Law Self-Defense member Jada. That's a new name to me. Are you a new member, Jada? I think Trump wants to do way more, but someone is advising him in the White House to keep playing nice in the sandbox, and that is not going to work. Mike Johnson just blocked Boasberg. Boasberg is the chief judge in the Washington, D.C. circuit. Mike Johnson just blocked Boasberg's impeachment, and Justice Roberts just claimed they're supposed to check Trump. I did see that. I should have pulled that up, that interview with Roberts. That is, in fact, not the role of the Supreme Court. And in any case, not the role, certainly, where the executive branch is functioning within its Article II executive branch core and plenary powers. Jada says we need a job swap between Stephen Miller and Pam Bondi. Stephen will light that fire and start arresting and firing people. He often reads from the Constitution. That's a good thing to do, right? The foundation of our nation's structure. Will says, question, what all is involved in the lawsuit that's been filed by America First against the judiciary? You'd have to send me a link or something. I'm not sure. There's so many. There's scores of these lawsuits flying around, folks. Phil says, spitballing here, and this is admittedly a pretty extreme thought, but will the district with district court, it jumped away from me. With district and appellate court judges, will they ever stop assuming powers they are not lawfully assigned, as some of them are not arrested, tried, and convicted? Roberts isn't going to willingly or reluctantly rein in inferior court judges unless he is forced to do so. Well, the arguments are going to be made straight to the Supreme Court's face on these unlawful TROs and injunctions, and we'll see what he has to say. I think at some point, President Trump, as I've often said, not only has the constitutional authority, the Article II executive branch authority to reject lawless orders from these judges, ultimately he has the constitutional Article II executive branch duty to do that, to preserve the core and plenary powers of the Article II executive branch from all enemies, foreign and domestic. Law Self-Defense member Phil says, says, Phil, I think there should have been arrest for this a good while back. I don't think Pam Bondi has the balls to have judges arrested for abusing judicial authority and obstructing the Article II executive branch. You have to start impeaching and removing from the bench for failing to serve during good behavior. You have to start taking aggressive action against these judges. The only thing that will mitigate their misconduct is their fear that they could be removed from the bench. They definitely don't want that to happen. Phil says, my personal feeling is Mullen lobby regarding judges threatening administration officials, but I don't know what the long game Trump and its advisors are playing. I think they're just goading the judges to put themselves in such an obviously illegal and constitutionally unsupportable position that the administration can move with assurance. I think so. I think that's right. Is it solely up to Roberts to check these courts overreaching? No, Congress can do it. Congress can do it. Especially every court except the Supreme Court is a creation of Congress. Congress can just eliminate the court. Article 3 of the Constitution calls for a Supreme Court and such lesser inferior courts. The Constitution literally calls these inferior courts. It's not, I didn't make up that word. Every court but the Supreme Court is an inferior court, is created by Congress at its will, at its pleasure.
Thanks for watching this highlight segment of our full-length Law Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.